My Lords, I'd assumed that the noble Baroness had risen to move or to speak to the amendment number 80, the amendment standing in Lady Pinnock's name. May I speak to the group of amendments in my name in this group? But although there are 8 of them, they fall into 3 broad topics, so I hope to dispose of them fairly quickly. The first are 80 and 81, and these relate to the ability of right-to-manage companies to bring legal proceedings and charge the costs to the service charge. The effect of the bill is that freeholders will not be able to charge legal costs to the service charge unless they obtain a ruling from a tribunal. In the case of right-to-manage companies exercising the functions of the freeholder, they have no source of income apart from the service charge. And if they're not able to charge their legal costs to the service charge, then they will not be able to bring legal action at all. In fact, without that ability, they would not even be able to initiate legal action unless the directors of the company were willing to fund the preliminary legal activities from their own pockets. And of course, if they were willing to do that, and they proceeded to court, they might find that the court or tribunal did not find that they were entitled to recover their costs, or found that they could recover only part of their costs as a result of that. And again, they would have no recourse to any source of funds apart from their own individual pockets in such circumstances. The Second Amendment, 81, extends this to not just right-to-management companies, but also residential management companies, which are slightly right-to-manage companies were established under the Commonhold and Leasehold Reform Act 2002. But there are other resident management companies that exist that are not right-to-manage companies under that Act. So these 2 amendments are alternatives. They're both probing. Now, I have heard that the government is aware that this is a problem and is willing to do something to address it. So I'm hoping that this particular probe will find a positive response from my noble friend on the front bench, because it cannot seriously be the government's intention to make it virtually impossible for anyone to become a director of a right-to-manage company without having to face very serious personal financial risks that were never envisaged when RTM companies were established in 2002. 81B, 81C, 81D and 81E all work together, and they relate to a different problem, which is that the bill currently allows a court or tribunal to award costs to a freeholder in certain circumstances specified in the bill. But if these costs are not paid, the only recourse the freeholder has is to go back to the court and to seek a new judgment to have the costs awarded to them. Whereas, in fact, the normal method of dealing with such a matter is to make a simple online claim for a judgment in default. Now, that course of action is precluded, as I understand the bill, in the case of freeholders seeking to recover the legal costs that have been awarded to them. And all this will do is burden the courts with more applications, which can and should be, and are normally dealt with, through an online process that takes a few weeks to complete. I mean, not filling in the form, but a few weeks to go through. And that surely should be available to freeholders. The third group, or the third topic in this group, is with amendments 82A and 82B. These, again, are probing amendments to seek to understand why it is the government is extending this protection in relation to legal costs to all leaseholders, when surely the intention must be to extend it to those leaseholders who are homeowners, that is, who own the property, which is the subject of the legal dispute. What the bill has the effect of giving this protection also to investor leaseholders, those who hold the property entirely as an investment. I do not understand the government's logic in doing this, and this is why these amendments probe that by suggesting that it should benefit homeowners only.